Good morning. My name is Luciana Norberg and I'm a tax partner of Trent Halsey Watanabe, for those of you who doesn't know me yet. And I want to thank you so much for taking the time to listen to us today. I hope that you and your loved ones have been keeping safe and healthy, and that social distancing has been treating you as well as possible. Thank you very much for being here. Before starting our discussions today, I have two messages for you. The first one is that I apologize in advance and on behalf of all our speakers for typical home office interventions that may happen during our presentations. So we hope you won't mind and you even laugh with us if in the background you hear children crying, dogs barking, or intercoms. You know that that happens every time, so apologize in advance. Please bear with us if that happens. The second message is that if you have the opportunity to see the opening session, Simone briefly introduced the launching of our book, which is an ebook actually, and it's written in Portuguese, so unfortunately it's only at this stage for our Portuguese speaking audience. But it was written by the tax team of Trent Halsey Watanabe, and it is entitled Currently International Tax Matters. Some of the articles that are included in the book are also the object of discussion from our conference here. So this is the case of this session. There is an article on digital services taxation in the book, and there is also this panel that we have now. The book is available for download at trenthalsey.com, and it will soon be available at no cost at the Kindle platform. And if you download the book and you see any topics that you would like to have a further discussion on, please feel free to reach out to us or reach out to the authors of that specific article to have a separate discussion. We're super happy to have separate sessions with you on all the themes that are addressed in the book. And now, kicking off our presentation, I would like to introduce to you our speakers. As I already mentioned, I'm a tax partner of the São Paulo office, Trent Halsey Watanabe, and so is Adriana Stamato. I'm focused on international taxes. Adriana is focused on indirect taxes. And with us, we also have the team from Baker & McKenzie. Javier Blasquez is a senior associate of the Barcelona office. Juliana Marques is a senior associate at our San Francisco office. Simone Bridges is a partner at our Sydney office, and Diana Martinez is a partner of our Mexican office. They are all the Baker McKenzie experts on digital service taxation, and they are here representing their regions. So Adriana will speak for Brazil, Javier will speak for Europe, Juliana will speak for the US, and Simone will speak for APAC, and Diana will speak for Mexico and LATAM. And finally, last but not least, we're very honored to have Pedro Gomes with us. Pedro is the VP for Tax and Treasury at Gympass, and he's very experienced on the digital economy. Since before joining Gympass, he was the director for LATAM at Uber. And before that, he was the head of tax in LATAM for Groupon. So thank you very much, Pedro, and my colleagues from Trent Halsey and Baker & McKenzie for joining this conference. So going briefly through the agenda, first I'll provide an overview of international trends regarding digital service taxation. Then my colleagues from Baker & McKenzie and Adriana from Trent Halsey will take us on a round the world tour. So they will explain where we stand in terms of development of legislation in LATAM, Asia, Europe, US, and of course, Brazil. Then Juliana will go a little bit further into the detail of the US tax system and changes, because we know that the US is a very important player and most of the digital service companies are either located in the US or were born in the US, so the US has a lot to say about digital service taxation. Then we will address the current challenges that we see from a legal perspective. And finally, Pedro will share with us the industry response. So he will share his pains, and we will go into a debate on where are the weaknesses, what are the cases of success, and how we can help to make this this new tax system more efficient and also friendly to the companies that are in the digital services taxation field. So, setting the scene a little bit. So the current tax systems, as we all know, they are designed to allocate tax collection based on the existence of physical presence. And in fact, physical presence has always been the main element when determining the location where value was created. However, in a digital world, as we know, physical presence can no longer be seen as the sole or even the main measure for value creation. The increasing number of digital platforms and the profits of those digital platforms, such as Amazon, Google, we know them very well, they lead us to the conclusion that an adjustment to the tax systems is inevitable. And otherwise, we will never reach fairness in tax collection. So tax should follow progress, right? And this is where we stand today. We're not only witnessing, but we are actually having to think outside the box to help build a whole new tax collection model that is different from everything that has been previously conceived so far. So we need to, tax needs to match the development of the digital world, and this is where we stand right now. And in this context, two paths are being concurrently pursued. One is being led by the OECD, and it's based on the recommendations of Action 1 from BEPS. It refers to a multilateral measure whereby countries would agree on an allocation of profits and not revenue, not taxation at source, but rather an allocation of taxable profits among the jurisdictions where a multinational group that provides digital services operates and where services are also consumed. So it's really splitting profit allocation, which makes sense, of course, if we're talking about BEPS. And then the other path that we see flourishing are the unilateral measures that are being implemented by countries to tax consumption in spite of the lack of physical presence of multinationals in those jurisdictions. So today we see two roads being followed in parallel. And one of the challenges, and we're going to debate that soon, is how to harmonize those two and what will be the future considering the multilateral approach and the unilateral approach. Respect to the OECD, I will not go that much into the detail. I just want you to know that, because otherwise we will need a whole webinar just to discuss the OECD initiative. But what I want you to know is that the OECD report divides the analysis into two pillars, Pillars 1 and Pillar 2. The report on the blueprints for Pillar 1 has just been finalized, and we are expecting soon a report on the blueprint for Pillar 2 in the upcoming weeks. The idea is for the OECD to reach a final recommendation on this multilateral measure by the end of 2020. So soon we expect to have a better view of what the OECD is foreseeing in terms of allocation of profits generated by companies in the digital services economy. As I mentioned, I will not go into the detail of Pillar 1 and Pillar 2. The message here, just for you to know that it exists, and that the difference between them is that Pillar 1 is based on the profit attribution between countries, depending on the activities that each country, that a multinational group is performing in each country. So the country of residence will actually, according to the blueprint, the country of residence would actually tax a share of the residual profits. The country where the multinational provides marketing activities will tax profits based on a fixed remuneration, and the countries of consumption or where other activities are also being carried out will be taxed, will be entitled to tax an additional return. And then the country of residence should give credit for the taxes paid in the other jurisdictions. So these are the main. As for Pillar 2, Pillar 2 is a global anti-base erosion. So it works kind of like a CFC. The idea is to make sure that the profits are, the profits related to digital services are subject to tax at a minimum effective tax rate, either in the country of consumption, the country of residence. Then we'll see what will come from the blueprint of Pillar 2. But the idea is that there should be a minimum level of taxation over such profits. And then this is just, I think this is interesting information. The overall impact that is expected by these measures is that there will be an increase in tax revenues of over $100 billion annually. So it's quite substantial. And of course, it impacts all multinationals that work with digital services. So it is expected to be a big change in tax collection. And this might even be further increased because of the COVID crisis, because the digital world is becoming so more important, which is something that we didn't expect to go that fast until last year. So at the same time that the OECD is working on the blueprints and on Pillar 1 and the rising of unilateral measures. And these unilateral measures, they take three forms: withholding tax, extraterritorial VAT, and digital service taxation. The common feature between them is that they are all very simple. They are all based on the place of consumption, and they are all applied on a gross basis. So none of them considers profit. They really consider the gross, with some difference between them. The highest, the most important difference is that withholding tax and extraterritorial VAT, I'm sorry for that, they are creditable normally. Withholding tax creditable at the country of residence of the beneficiary of the income, while VAT can become input VAT. DST, on the other hand, is always a final cost. There is no credit system, at least so far, for a DST. And however, the rates of the DST are much lower than withholding tax and VAT. So that's the difference between them. And that's what we're gonna see when we take our tour around the world. We're gonna see how countries have been adopting these measures. And then where will the debate go? What lies ahead? It's still very uncertain what will happen with respect to the digital services taxation in the world. The first question is the OECD going to be able to reach a consensus by end of 2020? And what will be the model that such consensus will be reached? And what will happen with the unilateral measures that are flourishing, that are being put in place? How to harmonize both? How to avoid double taxation? How to ensure that there's not going to be harmful tax environments once we have the multilateral measures and also the unilateral measures living in the same tax system? How to harmonize them? I think these are the main questions today. So I'll pass the word now to my colleagues from Baker & McKenzie and to Adriana to take you around the world. Javier, do you mind giving us the panorama and speaking about Europe a little bit?
Yeah, sure. Happy to do so. So as you were mentioning, the international debate / consensus is on the table. Actually, a few weeks ago, I wrote an article which was saying basically that many companies are digital or conduct a major part of their business digitally. 9 out of the world's 20 largest companies by market capitalization are digital, compared with just 1 10 years ago. So why I'm saying that? This is just to explain this map and to say what is going on in the tax world and specifically in the DST world. First, if we compare this map to the same one a few years ago, the map is getting more and more and more and more blue, and I'm pretty sure that next year is going to be even more blue. This map, I would also highlight that this is extremely dynamic and is changing constantly. So the anchor topic here is, we were saying, tech companies often generate businesses and profits without any physical presence, because actually this is no longer essential. So what can we say from this map here in Europe? What is going on here in Europe? Why the European Union was not highlighted as one of the key players on the global consensus in your introduction? Well, the thing is, the EU has tried to solve this issue on international companies, but unfortunately failed. To make short a long story, in 2018, the European Commission published a package of fair taxation of the digital economy, and this package contained two directives. The first one was like a long-term solution, the significant digital presence, which was basically saying that member states would be able to tax profits that are generated in their territory, even if a company does not have physical presence there. This is a sort of virtual permanent establishment, P2.0, or whatever you want to call it. And then on the second directive, there was a short-term solution, a digital service tax at EU level, at a tax rate of the 3% on gross revenue from digital services. Why do we have then so many unilateral measures? Just for you to know, in the EU, to move forward directives and to implement them, unanimity is a must. However, last year, for countries, Denmark, Finland, Sweden, led by Ireland, well, consider that they have availed themselves of the EU proposals, imposing their veto on the mentioned directive. So we can say that, well, this opportunity for the EU to, legislate the digital economy is gone, and actually current draft directives are dead. So, I mean, this is something that now falls, as said, to the OECD and the G20. What about the figures? If we get some figures from this map, about fairly half of all European OECD countries have either announced or proposed or implement a DST. Just to give you a few examples, Austria, France, Hungary, Italy, Poland, what else? Turkey and the UK have already implemented DST. There's like a second basket. Belgium, the Czech Republic, Slovakia, and Spain have published proposals already to enact DSTs, and some of them, as this is the Spanish case, are awaiting for parliamentary steps. And then we have a last basket, which is including Latvia, Norway, and Slovenia, for instance, that have either officially announced or show kind of intention to implement DSTs here in Europe. The proposed and implemented DSTs differ significantly, essentially in the structure. For example, while some countries only tax revenue from online advertisement, France or Spain have a much broader scope. Also, the tax rates differ from 2% in the UK to 7.5% in Hungary and Turkey, although Hungary tax rate is temporarily reduced to 0. And the last interesting case is Poland, which is a country publicly in favor of a multilateral solution, but in the meantime, and because of the COVID-19 measure, has implemented a 1.5% tax on online streaming and video on demand services. What else? How is this structure? I think this is somehow all about politics. It is also interesting that inside the countries, respectively of their current position on the DST, there is also internal debates. For instance, here in Spain, let's say that the leftist political parties support current DST proposal, but on the other hand, political parties in the middle and on the right support a global consensus, even though, and this is like a complex internal thing, originally the DST in Spain was proposed and tried to be implemented by the right party, or the main right party here in Spain. So in the end, there is political flavor of the DST at each level, local, European, or international. This is a definitive map. I would say that no, because as I was saying, was pretty dynamic, and I think, or can a political decision or can the outcome of an election change a unilateral measure? I think the answer is yes, definitely. This is a unilateral measure with international consequences. Actually, yesterday we had breaking news on the UK. The UK, as said, has approved a DST this year, but in parallel is involved in the post-Brexit negotiations, which include trade negotiations. So the UK estimated DST collection was around £500 million. But yesterday, Rishi Sunak, who is a UK tax counselor within Boris Johnson's team, stated, and I'm quoting him, that DST is more trouble than it is worth. So, you know, given that UK DST could be an obstacle to the post-Brexit trade talks between Union and Washington, D.C., maybe the UK is going to step back on this shortly. Last topic, are these unilateral measures going to last forever? Well, although most of these DSTs measures are generally considered to be interim measures until an agreement is reached at the OECD level, actually some of the DSTs in the map contain a sunset clause derogating local provisions once this international consensus is reached. It is somehow unclear whether all of them will be and how will be repealed at that point, or what would happen if the OECD consensus is reached under well, different circumstances, or is not reached at all. So this is fairly what is going on currently here in Europe.
Thank you very much, Javier. I hope you're right when you say that once we have consensus from the OECD, the unilateral measures will be softened. Otherwise, it's just, I'm afraid that it's going to be too heavy on the companies.
Yeah, but I hope.
Diana, can you let us know what is your view in LATAM? I find it harder to believe that LATAM would just eliminate the unilateral measures once we have consensus from the OECD, but please let us know your thoughts.
Sure, thank you, Luciana. Yeah, I agree. I don't think that it's going to happen here in Latin America. Actually, there was an interesting case. It was Mexico. It did present a DST proposal on 2018, but of course, this proposal was not really good. It was like a copy paste of the European Union proposal, so it wasn't even discussed in Congress. What the region has been focusing on is on extraterritorial VAT. As you've mentioned, it's kind of a simple tax, but certain countries have not been having an easy transition to these extraterritorial VAT. The most important example of this, I think it's Mexico, but of course, Mexico based its proposal on Argentina and Colombia's proposal, which are, I think they were enacted on 2018, both of them, and they've been trying to implement these extraterritorial VAT for a few months now, but they've been struggling with implementation also. I will focus on Mexico. We have certain differences with Argentina and Colombia, and definitely Mexico has been one of the most complex VAT, extraterritorial VAT, to implement and even to understand from starting from the legislation that was enacted on December 2019, but actually entered into effect on June 1st this year. So we have just a few days, few weeks with this new VAT. The main idea of an extraterritorial VAT, of course, is to tax digital services that are rendered by foreign digital services providers. In the case of Mexico, the services that are being included or in scope of these VAT are mainly streaming services. I say streaming services, but actually this first section is quite broad. It's being very difficult for companies to understand whether other services apart from streaming services are being captured by this first section. The reason is that the wording of this first section is quite ample. The wording is actually downloading or access to images, movies, texts, all these kind of multimedia. So the question is whether software, for example, is being included here, software as a service, even data storage services, although in the first proposal that was being discussed last year, data services and data storage services were eliminated from the proposal. So we can say that there are interpretations that say that only streaming services should be included in this first section. The second service are intermediation services. I will stay a little bit on this one because it's been also quite difficult for companies to understand what the legislator meant by intermediation services. In the explanatory text, they mentioned that mainly these intermediation digital platforms that are being covered are marketplaces and sharing economy companies. However, there are a lot of other business models that could be captured by these broad definition of intermediation services as well. And this one is very important because if you are captured by these definition of intermediation services, then you will have withholding obligations if you are rendering services, these intermediation services to Mexican vendors or Mexican service providers. So then these digital platform would have to withhold income tax and VAT that pertains to this Mexican vendor or service provider. And of course, this has posed a lot of complications for example, marketplaces and sharing economy companies to try to comply with these withholding obligations. The other two are not that complicated and maybe not that important, which are online COPs and dating websites and online training services. The collection mechanism here in Mexico is to have a registration by the foreign service providers. In other countries, what they did was to transfer the burden of the collection to financial institution or financial intermediaries. I'm not sure which one is better, but I think both of them have their complications. In Mexico, actually, registration has been quite complicated because it was amidst the pandemic, and the Mexican government did request a lot of formalities that they were not willing to give up. So this posed a lot of complications for many companies. I think Chile has also a registration system. And of course, maybe the most important topic is whether these services that I've just mentioned are only related to B2C transactions, which should be the case because, as you know, businesses are already complying with this reverse charge mechanism that already exists in most jurisdictions in connection with VAT. But the example of Mexico is not clear whether this is the case. What the legislator explained is that these services are generally considered B2C transactions, but this is not explicitly mentioned in the law. So if you are a streaming service company rendering services to a business, then you should comply with these new provisions. That's mainly the overview of the region. Of course, Adriana, maybe you can explain Brazil, which I think it's also a quite complicated tax system.
Who told you that, Diana? It's not true. I mean, of course, everybody knows that Brazil is a very original jurisdiction when it comes to indirect taxes. And I believe that we are a little bit behind our colleagues, our neighbor countries. First of all, I'll start with what is totally different. We don't have a single VAT. We have 4 different taxes that apply on services and goods. We have turnover taxes, which are PIS and COFINS. We have ICMS, which is a state tax on goods. And we have ISS, which is a municipal tax on services. And one of the Achilles heels for the digital economy taxation is really to determine what is a good and what is a service, because that will be key to determine whether the company will be paying ICMS to the state or ISS to the municipality. This is a discussion that has been going on for quite a long time. We don't have a clarity yet. There are some very relevant pending cases before the Supreme Court that probably will rule, I believe, that in the near future, and that will clarify what is the position in terms of software services, software and other types of digital services. So this is one important point for you to have in mind. The other important point is that we do have extraterritorial VAT. It's different from in other countries. It is a reverse charge. So when you have a B2B, the companies, the Brazilian companies that are importing services or goods or whatever, should be paying all of those taxes. But when it comes to individuals, even though there is this obligation in theory, in practice, this is very hard for the tax audit, for the tax fiscalization to make sure that the tax is being paid. So with that in mind, we have to understand what are the proposals that are being discussed right now regarding the Brazilian tax reform. We believe that something is going to change, but it's really very hard to anticipate what will come in the future and what will be the change. We have in one hand 2 constitutional amendments proposal to unify all of the indirect taxes and create a single IBS, which is a type of VAT on goods and services. So we have 2 constitutional amendments proposals that are, being discussed before the Brazilian Congress. They are very, I would say, aggressive in terms of getting a consensus, because of course you will be eliminating a lot of taxes, you will be taking power of the taxing authorities, everything will go, to a single tax. And of course, there's a lot of debate going on whether this will fly or not. In parallel, the federal government presented 3 or 4 weeks ago a proposal that is going to be a 4-step tax reform proposal. The first step being the unification of PIS and COFINS and creating just a single tax, which is going to be called CBS. So CBS will be also a turnover tax, but they created an obligation for the platforms, for the non-resident platforms, also to withhold the CBS when they are intermediating services. So we have, something different going on in this proposal by the federal government. And apart from that, we have 2 bills of law that have been filed by congressmen in Brazil. And what they are proposing is a type of DST, meaning that it will be due by big tech companies. There are different thresholds in terms of what are the revenues targeted, what are the services targeted is pretty much the same. It's advertising, it's marketplaces, and it's user data collection and transmission. The rates vary a little bit as well. One is, there's a progressive rates and the other one is 3%, but both of them are like CIDEs. CIDEs, you may have already heard this name. CIDE is also a Brazilian tax, it's a very original tax. And the purpose of the CIDE is to
harmonize, is to balance one sector of the economy so that the federal government will act in that particular sector, collect funds, and the funds shall be used to remediate and to balance again that sector. So these are the purposes these are the proposals that we have on the table right now. I believe, in my view, that currently those DSTs proposals, they are not being backed up by the federal government. Of course, everything may happen. We are talking about Brazil, but in theory, the federal government proposal does not contemplate the DSTs. So by now, I believe that at least for some period of time, we will still have to live with this dispute between ICMS and ISS for the VAT, unless these constitutional amendments proposals are implemented. And in the near future, we don't see the GST projects being implemented, but of course, we are keeping a very close eye on that. So Luciana, I think that this is what we have right now. I think just one final comment on the GST proposals. On one of the proposals, the non-resident entities will be required to register in Brazil. On the other one, there is no, in the proposal, in the bill of law, there is no provision on the registration, but of course that will come because they will have to pay taxes in Brazil. So of course there will be some type of registration. So that's what we have right now.
And I think, Adriana, if you agree, it's also worth commenting that Brazil is currently not a member of the OECD, but it's applying to become one.
Absolutely.
Yeah, so if the multilateral measure is adopted, it might be that in Brazil we have to live with the unilateral measures plus the multilateral measure of the OECD.
Yes, that's true. That's something that has also been on the table for quite a while. There's a lot of political pressures and disputes around this issue, but you are totally right. We may have that situation as well.
So thank you, Adriana and Diana. So moving forward to APEC. Simone, can you give us the overview of what's going on at APEC? We see additional bullets here in the slide, so I guess you have even more news to share with us.
Sure, thanks very much. So from an Australian, from Asia Pacific perspective, unlike Europe and some of the other regions, in APAC, there has been a real slow movement to adopt a DST or unilateral measures. There are some exceptions to that. So firstly, in India, they were the first country to move on implementing a test that essentially will tax based on a significant economic presence, and also an equalisation levy, which has its origins in BEPS Action 1. And then secondly, Indonesia has a significant economic presence test. So that's what Asia Pac has been doing on a unilateral measure basis, on a non-indirect tax basis. So we've been pretty slow to adopt any DSTs. What we have done in our region is been quite active in respect of a extraterritorial VAT GST. And so what we've seen that since 2015, the Asia Pac region has slowly adopted extraterritorial taxation for non-residents that are supplying to consumers in the respective jurisdictions. So essentially, the main issue in APAC is that, like other regions, there's no consistent approach on how the extraterritorial VAT is defined and applied. And so this presents a lot of issues in practice for businesses. And so on this slide, I wanted to highlight a few of the key themes coming out in my region and some of the approaches that countries have taken. So essentially, there's no one universal definition of what's captured in terms of extraterritorial VAT. The three countries that have a broadly consistent definition are New Zealand, that implemented their GST on extraterritorial supplies in 2016, Australia in 2017, and Singapore most recently in 2020. So those three countries have a very broad definition of what's captured. Essentially, it's any cross-border supply, intangible supply or a service that is made remotely into the country, supplied to a consumer. And so there's no prescriptive list in legislation of what's included. The tax authorities in those countries, they give guidance on what is included, but it's not in legislation. And so that also allows those taxing authorities the flexibility to change and add things over time, to evolve as businesses evolve. And so that has been helpful for some clients, but not helpful in that there's no certainty as to what is the next thing coming around the corner. In terms of Malaysia, Japan, and the Philippines, they are more prescriptive in what's included. But those countries, they don't differentiate between business to consumer supplies and business to business supplies. So as it was previously mentioned, that cross-border supplies to consumers are generally what's captured in an extraterritorial VAT system. In some countries in APAC, it applies to B2B and B2C. And that's because some countries in the Asia Pacific region don't have a reverse charge mechanism. Their regimes have not evolved to capture a reverse charge way of B2B supplies. And so notably, the Philippines, they don't have a cross-border B2B reverse charge. Singapore also did not have a cross-border B2B reverse charge until very recently. And so Asia-Pac region, because unlike Europe, which is very experienced in terms of VAT because it has been around for a long time, the VAT regimes in APAC are slowly evolving, and unfortunately they're not very consistent. So it has presented some challenges to businesses in making sure they can comply with all these regimes that may or may not capture them. And so in terms of the collection mechanism for the extraterritorial VATs, it's typically on the non-resident supplier, but there are some exceptions in that in Australia, Singapore, and New Zealand, they have marketplace rules. And so it was touched on earlier that some countries deem an operator of a marketplace to have the liability to remit the GST or VAT. And that's what we have in our region. So if you have an operator of a marketplace that facilitates the transaction between a supplier, a non-resident supplier, and a consumer in a jurisdiction, the operator of the marketplace would actually be the deemed supplier. And so for New Zealand, Singapore, and Australia, that means that the liability shifts to that marketplace operator. And so this is really intended to capture some of the really big players out there in terms of marketplaces and platforms. But because there's no large threshold, it also captures quite smaller platforms. So if you're a startup and you're a platform putting two parties together to contract, you could find yourself being the deemed supplier, having to register and be responsible for all of the GST and VAT flowing through your platform. So that's just something that has been unique in the Asia-Pac region, because Europe is now moving towards that way of taxation. And I would say finally, we're speaking about cross-border supplies of services and digital content, but in the Asia-Pac region, we have also deemed any supply of goods through a platform or through a marketplace or website to be captured by extraterritorial VAT. And so what that means is that if I do online shopping and I buy some goods and they're imported into the country, then the operator of the marketplace that facilitated that sale will have to register and collect the VAT and GST and give it to the government. And so that's what we see in Singapore and Australia, and that's called the low value goods regime. And Europe also has a similar regime that has been proposed in terms of low value consignment. But in our region, we were the first countries in the world to actually implement such a regime. And so I think we'll see more countries in the Asia-Pac region moving towards that. I think that's kind of a roundup from APAC.
Thank you very much, Simone. Juliana, can you take us to the US? By the way, so that everybody knows, Juliana is Brazilian, but she's been living in the US for quite some time now.
Half of my life, yeah.
Yeah. So
Thank
please,
you.
Juliana, if you can take us on the US tour.
Yeah, sure. So the US doesn't really have a VAT system, although we do have what we call a SALT system. So states have this sort of comprehensive tax regime and their sales tax that vary by state. So the US response has really been focused on the various DST developments that Javier was talking earlier in the presentation, and then we heard from Adriana and others. And the response from the US has really been swift, somewhat atypical, and in many ways unilateral. Section 301, which was added to the US Trade Act in 1974, grants the US Trade Representative, or the USTR, the authority to investigate and to take action to enforce US rights under either trade agreements or in response to certain foreign practices. And while it gives USTR this sort of broad discretion to act, it has not been the main mechanism for the US to pursue action in the context of trade violations. And it's going to make sense in a second why I'm talking about trade violations, because, you know, the US view of the world has been that the DSTs, the digital service tax, are in violation of agreements that these countries have with the US or in violation of the WTO agreement. Which is the GATS for services. And what we have seen instead was the use of Section 301 to primarily build cases and pursue dispute settlement within the World Trade Organization, or the WTO. This has changed with this current administration, and President Trump has been more than willing to unilaterally act under Section 301, which is a US statutory section, to promote US interest. And this administration has been busier than previous administrations in reviewing this perceived gap that between US and foreign government practices that are viewed by the US as discriminating against US companies. And this has resulted in either renegotiation of trade agreements, the withdrawal from certain trade agreements, and in the more serious cases, the imposition of tariffs. Moving on to the slide here, where we see the Section 301 investigation into the DSTs. As many of you know, in 2019, USTR initiated an investigation into the French DST. That was the first one of the DSTs to become effective, with a tax liability accruing as of January 1st of 2019. And the USTR determined that the French DST was in violation of Section 301. That happened at the end of 2019. And you can see in this picture, this is a picture of current USTR Bob Lighthizer and his tweet right after the conclusion of the French DST investigation, warning countries that the US will investigate measures that discriminate against US companies. This is very much in line with the strong stance and sort of the quick Twitter fingers that our current administration uses. But true to his word, in June of this year, of 2020, USTR opened an investigation into 10 other measures, and they're listed here in this slide. Some of them have been addressed by Javier already. Moving on to the next slides, we can see in terms of the elements that are necessary to prove a Section 301 case, you would have to prove that a foreign country either violated a US trade agreement, as I mentioned, or engaged in an act or acts, like for example, by enacting a tax measure that are unjustifiable or unreasonable and burdensome to US commerce. And several factors can support this actionable determination. There's no weighing of factors, there's no super factor, but there's a more holistic review of all of the available evidence to determine if in fact this tax measure violates Section 301. And the first thing that the French report that was published in end of 2019 determined was that the French DST actually discriminated against US digital companies. This discrimination aspect against U.S. companies is something that we would expect also to see as a determination of the current Section 301 investigations into the 10 other measures. And one important point on the discrimination is that even if the DST does not appear to be discriminatory, because on its face, the application of the DST is not exclusive to U.S. companies, if the DST still has the effect of largely and disproportionately subjecting U.S. companies to tax, it is de facto discriminatory. Some of the evidence of discrimination can be more overt, as would be the case, in the context of the French DST. There were all the statements made by French legislators that said that the tax is being passed as a way to tax U.S. digital giants that, quote, don't pay their fair share of tax, unquote. So that was an intention to target U.S. companies. But even if there's no sort of overt statement, there may be other aspects of the law, of the DST law, that can prove discriminatory. One example is the scope. If the scope of the services, online advertisement, intermediation service, the transmission and sale of data, if that sort of ring fences a portion of the digital economy where U.S. companies are dominant, that would be in effect discriminatory. And even where the scope is not discriminatory, there are global and local thresholds in the DSTs that have the effect of including large global U.S. enterprises, but at the same time excluding local digital suppliers from the scope of the tax. There were other important things in the report that are listed in the slides. We can move on, Luciana, to the sort of reactions that we have seen from here, government responses. In July, USTR issued a list of French goods that will be subject to a 25% tariff if France does begin collecting DST from US companies. These tariffs are in the amount of 1.3 billion on French good imports, and that's consistent with what we think the impact of the French DST would be on US companies. We had President Trump and French President Macron agreeing to a delay of the imposition of these tariffs and a deferral of the collection of the DST until the end of 2020. But based on statements from Finance Minister Le Maire, who is a strong, avid supporter of DSTs, he has said if there's no international solution by the end of this year, France will resume applying the DST, in which case the tariffs will kick in on the US side. Some recent press reports indicate that despite the support from France and from Germany, the prospects of a European-wide digital tax is sort of losing steam, not as strong. But despite this threat from the US, most countries that are under investigation and even other countries that are not seem to continue to press forward on the DSTs, as my colleagues mentioned, and Brazil has decided to double down. And like Javier mentioned, just yesterday we heard unconfirmed reports that the UK DST may be scrapped as a result of the post-Brexit trade negotiations. So that might be one that may go away. That's a big one for US companies that have large presence in the UK, especially advertising companies. So that will be well received in the US for sure. Next slide, please. Sorry, you can go back. I have to just briefly touch on the industry response. So the Section 301, the second wave of Section 301 I was talking about into the 10 measures, it was open for public comment, and it attracted almost 400 submissions from the public, either digital companies, business organizations, nonprofits, or even smaller retailers and other companies that could be severely impacted by tariffs. Most of the comprehensive comments that were submitted, I did review the docket. They were seeking, they were encouraging the USTR to seek a negotiated solution many stating that the OECD is the best path to reach a consensus solution. So it kind of shows a disfavor from businesses on tariffs. I think nobody really likes tariffs, and this administration, I think, is using it as a way to protect U.S. Companies' interests. But it is clear that at least here, everybody would rather see a consensus solution to be reached at the OECD level. Next slide, please, Luciana. And just quickly, so before we wrap up, Luciana touched on this a little bit. In terms of what companies can expect in the next few months, there has been some speculation that the US will pull out of the OECD negotiations altogether in light of a recent letter from US Treasury Secretary. His picture is this slide. He was asking for a pause in the negotiations at the OECD level in light of COVID and the disruptions from COVID and economies needing to rebuild it themselves before additional taxes were imposed on companies. This was not well received by the international community, especially by some European countries. So the US is still part of the technical discussions on pillars 1 and 2. We now have drafts of both. So it's clear that the negotiations, or at least on the technical aspects of the proposals, are ongoing. And in parallel, the Section 301 investigations into the 10 other measures will proceed. We have here in the U.S. upcoming elections in November. While protecting American companies is a bipartisan issue that has support from both political parties here in the U.S., it is unclear whether, if Biden were elected, whether he would maintain Trump's and his administration posture on trade negotiations, the use of Section 301, and the use of tariffs. I've heard from a trade lawyer that we should expect that USTR will conclude its review or the Section 301 investigations before the elections or before a new president, if a new president comes in, takes office, with the goal of, having this administration have the ability to impose tariffs if it wants on other countries. I had another slide that we decided not to touch base on, but some of the things I just wanted to point out that other than the Section 301 investigation, there are other ways that the U.S. can maybe dispute the use of DSTs by other countries. One is, trying to argue that these are taxes that are covered under tax treaty, and therefore subject to treaty provisions of dispute resolution, etc. It's not a perfect path because it's not clear that the taxes are actually covered taxes, and the dispute mechanisms under treaties are not great. And then there's also the WTO dispute settlement procedures, which the US at least has viewed it recently, this administration has viewed it as not as effective, slow process, and in many ways not able to resolve issues, for example, with China, not as effective or irrelevant in the case of China. So so that's it on the US response. I think we can touch base on a couple of these concerns again later in the presentation.
Yeah, Julian, I think this is a perfect link to your next part of this session, which is the current challenges. We see loads of them in the US, or US leading the challenges, let's put it that way. Javier, can you help us on this discussion? What are the current challenges that you see?
Yes, sure. First of all, I think there is like a big difference from the the theory and the practical, because most of these challenges we realized of them once we were assisting clients. So I mean, from our experience, one of the challenges are the user data or the user location. This is a controversial aspect, which is actually the nexus between the income and the territory. Just to give you an example, for instance, here in Spain, DST law states a legal presumption by which the location of any digital device corresponds to an IP address. So, in other words, if the IP address is located in Spain, it is assumed that the income is captured here in Spain. And at the same time, the law states an obligation for taxpayers imposing penalties if users fake or hide the place of the realization of the service. Okay, and in some cases, these penalties can be significant. So my point here is this goes beyond the tax world and falls under the data privacy rules, legal provisions, etc. So what about if there are a minority of users and those users are using, for instance, virtual private networks, VPN, that allow online privacy and by creating a private network? Can the company monitor this? Why is the legislator imposing this extra obligation to the taxpayer? Why should it be the taxpayer actually obliged to this extra obligation? So I don't know, Pedro, could you please jump in? I think it could be great on this topic to have some industry's views, please.
Hi, Javier. Yes, so as part of my presentation, guys, I covered this a lot, but basically platforms, they work with a very low margin. If you get to a 20% margin, the investors will love you. If you get to the 10% margin, investors will probably be scary of you. So we work on this average between 10 and 20%. Companies that have a very healthy platform are working on 16, 17% of free margin. When I say free margin, I'm not getting fixed costs, okay, guys? So it's just the platform cost, supply and demand. And so if you create taxes that I have in average 15, 16, 20%, and you start to have discussions of taxation over the gross value of the service of the product, basically you're talking about getting the whole margin of the company and moving to the government, right? So it's absolutely impossible to have a world where we will have the platforms operating and at 15, 16, 20% taxation over the gross price of the service, because basically you are taking the whole margin from it. As part of my presentation, I'll explain a bit more how the financials work and how we make decisions surrounding taxation over digital services and technology in general. But it's a very good point on here.
Excellent. Thanks, Pedro. What else? We have also local interpretation, and I think it's specific. It is pretty relevant how the threshold is calculated. So in order to protect the small and medium-sized businesses and startups, taxpayers that are subject to DST are limited to those that have more than X million euros, dollars, or whatever on annual worldwide revenue. And there is also a local threshold, which is 50 million euros in the EU and 3 million euros, for instance, here in Spain. So what is relevant is to underline whether or not intercompany transactions, cross-border transactions, and domestic transactions are subject to the tax for the purpose of the qualification of the services at both thresholds. Or what about if just a business division of my company provides qualifying digital services? Does my remaining activity qualify for the threshold purposes? And as you can imagine, this is important, since a yes or a no to these questions may entail paying the tax derived from such a, let's say, minor activity. One relevant point also is retroactivity, and from my perspective, unreasonable implementation of timeframes, because several of the DSTs have been enacted without essential guidance. There is not always exemption, is the French case, but in general, we are talking about provisions, not extremely detailed. Just in Spain, the law has like 20-something pages. They are targeting a whole industry, which is the digital industry. But you know, every single player has a specific and unique or pretty similar business model. So once you analyze the wording of the law, there are tons of challenges, and there are multiple ways of interpretation. So you know, and also for the taxpayer, what is complicated is that some DSTs have been enacted with exceeding short time periods between the date of enactment and the date of an effective date. So this entails a huge internal burden for taxpayers to, for instance, well, gather internally figures in the way which is requested by the relevant country. So it is true that companies can take advantage of previous precedents. That could be the case of France, but in any event, some country by country tweak must be implemented. And last but not least, other interesting topic is its potential retroactivity. Can a new tax be implemented retroactively? From our experience, there are no or just a few precedents on this, and neither the domestic Supreme Court or Constitutional Court has something to say based on previous case law, and should be analyzed, you know, if the particular government is intending to give some degree of retroactivity to the DST provisions. And one more, and this is pretty painful, is the taxation on gross revenue rather than net income. So these essentially impose on gross revenue. So as Pedro was saying, we can discuss about this, but unfortunately this is what it is, and the DST does not allow for the deduction of costs from gross revenues, etc. So the truth is that the legislator is presuming that all digital companies are profitable, which is far away from reality. And as Pedro was mentioning, this have an impact on business margins, and the legislator is ignoring those business margins. So consequences of this, a pure tax approach, as we will see on the following topic, double taxation. A pure financial approach, what about the impact on the business margin? What are the financial consequences of this? And a pure commercial approach, what is the impact on my clients? I don't know, Pedro, if you wanna add something here, or everything was said before?
Yeah, so after this, in my slides, I can cover all this, Javier.
Okay, perfect.
It'd be easier to explain like how we do the math and everything.
Perfect, thank you, Pedro. One relevant topic is as well double taxation. So generally speaking, DSTs can create double taxation in two ways. First, double taxation will arise if the taxpayer, whoever it is, the US headquarters, the EMEA headquarters, or local affiliate, is not entitled to a tax credit in its residence country for the DST. So if there is no tax credit, that income inevitably is double tax. But there is like a second, let's say, minor double taxation, which is the lack of coordination between the scopes, definition, and the taxable base calculation among the different DSTs, which may have negative consequences. So it is feasible that a transaction that involves users in two countries can be subject to DST on the entire income in both places. For a quick example, Spain and France, a sale through an intermediary platform or an online travel intermediary services provider could be taxed in both Spain and France, depending on how is defined the service by France and Spain and how the taxable base is calculated. So this is a huge concern, especially for US tech giants. So Juliana, could you please jump in with some US thoughts on the double taxation, please?
Yeah, so the double taxation issue really is a issue usually of the resident country. The resident country usually has the power to grant a deduction or a credit for taxes that are paid by its foreign affiliates. And an example here of a transaction that could be subject to DST in two countries is you have an online marketplace where you have, let's say, a seller from the UK and a buyer from Italy. And both countries, since there's an Italian user and a UK user, would subject that transaction to DST. And you know, if you had 2% and 3% on one side, and those are gross basis taxes, you'd be like Pedro said, you could be paying up to 5% DST on the same income, and with no relief for the potential DST paid in each country. Now, the UK has been, I think, to date, the only country that has punted at this possibility of reducing the UK taxable income, DST taxable income, in cases where there is a DST applied by foreign countries, but it only recognized for other countries as countries that it would possibly give a credit for the transaction. So, you know, Pedro's, I think he walked us through some numbers, but if you have an issue of double taxation, no relief in the US, it could create a situation. And you know, as I was mentioning earlier, most governments have taken the position that DSTs are not covered taxes, so they're not subject to double tax treaties, which have the effect of providing for double taxation relief. So it has really taken them out of double tax treaties, and now you know, it's left for the U.S. to do this very complex review of whether a tax is credible. And a tax usually is only credible if it's a tax on income, and DSTs are taxes on gross revenue. So you know, in the US, it's not clear. I think one would say it's probably not possible to get a credit for any DSTs, although you would get a deduction against your guilty income, which is sort of your CFC's income. So you get some relief, but you're still subject to you know, more than one tax in the same item of income. And on the last point here, the extraterritoriality of these taxes, you know, the traditional system we've been sort of used to and operating under is that your tax on your physical presence or the source income that you have in a country, a non-resident is taxed based on this two sort of main factors. And now you're taxing countries based on where users are located, completely detached from where the income event happens, and many argue completely detached from where value is created under transfer pricing rules. So it does create a lot of challenges for companies to now try to think about how they operate, how they, you know, organize themselves, and this, depending on what Pillar 1 and 2 do, you know, have to say about this, and whether DSTs will continue following these negotiations, we can see a significant challenge for companies going forward, thinking about, you know, how to operate their business in a tax efficient manner.
Thank you very much, Javier and Juliana. Now let's hear from Pedro. Pedro, please share the good sides and bad sides of the industry. Share your opinion.
Okay, good morning, everyone. Luciana and team, again, thank you for inviting me. It's a pleasure to be here. I'm not part of the Baker team, of the Trinity Hospital team, so just for you guys to know who's talking to you, a small introduction here, short introduction. I have been working with Trinity Hospital and Baker for the past 15 years of my life. All of them as part of the finance team of global companies, most of them leading tax departments and almost always leading global restructuring projects, transfer pricing projects, and lately DST. My career has a lot of years, like 8 years in P&G, and then as Luciana mentioned first, Groupon, Uber, and now Gympass. I'm a lawyer, an economist, but most of all, I'm a person raised in a farm. So I'm a farm boy that loves dogs, sports, and betting anything that you can bet. So if you guys want to do a bet in the chat, I'm always for it. So this is a little bit about me. I'm Brazilian, living in New York for the past year. I will always remember that the year of COVID, I was here in New York enjoying this amazing city from my apartment. So guys, first thing, like if you go to the next slide, the first thing that I think there's a fundamental error in the way the governments are approaching digital service taxes, because they always look at this, okay, we need to create a new taxes to tax this new economy or this new economic sector. And digital economy, it's not a new sector of the economy. It's not a segregated area of the economy. It's an evolution of the economy. So when we talked about digital service taxes, we are not talking about companies that were not taxed before. We are just talking about an evolution of the economy itself. Digital economy, it's not a new economy. It's a new phase of the whole economy. So when you approach digital service tax as we need to create these taxes and it needs to be at the same rate of the VAT, or it needs to simulate the rates of a withholding tax or the income tax, in most of the case, we will be discussing a double taxation. Because it's not that it was companies and sectors that were absolutely informal regarding taxation. They were just being achieved by taxation in different ways. So mostly when you think digital service taxes, you need to address the topic of foreign companies and international companies that are doing business locally without a specific taxation of the transactions. What in the case for Brazil as an example, it's absolutely forgotten in the legislation discussion. It's just like, okay, let's create a DST because everyone else is creating and probably need to tax those guys as well. So it's very important that the governments, when analyzing unilateral measures for digital service taxes or to tax the digital economy, that they understand that the goal is to tax what was not being taxed before, not to double tax what was already being taxed. And this is something that the governments need to be more careful about. And I've been working in technology companies for the past almost 7 years of my life, when DST was not even something. It was not something that was being, legislation that were being enacted. But we were always analyzing the tax costs. We were always analyzing how much it would cost to be in country A or country B, or to have a shared service center in a specific country, or to provide service from another country. So the tax cost was always part of the equation. Right? When you think digitalization of economy from our angle, from the industry angle, basically what we are trying to do is to eliminate transactional costs. And we do this in order to create a disruptive, intense force over offer and demand in a way that the prices will shift into an equilibrium price that will make this service or this technology or this product available. So the digitalization of economy, it's something beautiful for the world, because we are talking about changing the world and making it better, making services and products and technologies that otherwise would not be available to a big part of the population become available through this very intense disruptive force over demand and offer. This is all about that. So if you go to the next slide, I just gave some examples here for people. If you see what those people usually do for the road, if you talk to those companies, if you have interviews with Elon Musk, Steve Jobs, Sandberg, and there's a lot of other people that we can mention about the mission of their companies, what they want to achieve, of course, they all made a lot of money. Of course, Jeff Bezos is trillionaire, billionaire, I don't know. But they all talk about their mission of making the road better, of changing the road. Those companies' mission is about bringing people together to do business or to do business in a different way so they can eliminate transactional costs and change the world. So there's the mission for the technology companies. And this is what we want to achieve with the digitalization of the economy. To give an example, I worked for Uber for 2 years. The idea of Uber came, and Travis, the founder, likes to say this, in a Year's Eve, after a Year's Eve party in Paris, where he was kind of drunk, walking back to the hotel because he could not find a taxi. And he told his friend, okay, I would pay $1,000 to get a taxi now to the hotel. And they start to think, okay, if the taxi drivers knew that we are willing to pay $1,000 to get to the hotel right now, how many drivers would show up here? So this full information to the both sides of a service, supply and demand, on talking about how much people are willing to pay or how much people are willing to get to provide a service, to do a product, to do anything. It's what the digital economy is about. It's eliminating misinformation, asymmetric information, and eliminating transactional costs, bringing the equilibrium price down to a point that a lot of more people will have access to the services and to these technologies and to these products. DST basically, or other type of transactional costs, basically will kill this benefit created by digitalization. Because when you do a DST, you simply create another force to shift price up again. So everything that we are trying to achieve with digitalization, of eliminating transactional costs to a point where service and technology could be available to more people, DST reversed. And the governments need to understand that basically when a DST is created, from our angle, in the company side, we have this discussion, okay guys, so we were able to provide, in my case, GymPass. We were trying to help people to find an activity to do something, to have a healthier life, to take care of their well-being through better prices in these monthly subscriptions. And then a DST comes, and the only thing that we can discuss is to increase prices. And when you increase prices, again, you are shifting the curve. You are shifting the balance of the curves of offer and demand. So basically, with this unilateral measure from government A, this government could be actually changing or killing a huge benefit that was created by a disruptive, amazing force that came with the digitalization, right? And what I realized is that they don't think about that when they create DSTs, unfortunately, right? They just think about, okay, those guys are becoming rich, they are not paying taxes, they have these huge margins, we need to charge taxes. But it's not true, okay? Of course they are rich. Of course the companies, those companies here are doing super well. But the margin is not that high, because if we will operate with very low margins in order to bring the product, to bring the technology to more people. It's not that not having the taxes, we will be able to keep the price. Taxes created, especially unilateral taxes created without seeing the full picture, will bring the price up. There's no other way, okay? So if you go to the next slide, please. It is what I was saying, like, so when we come here to work every day at GymPass, as an example, our mission is very clear. We need to fight inactivity. We need to help people find an activity to love. We need to help people to be more healthier and go to gyms and go to fitness facilities, or even at your home to get a digital service related to well-being and those things. Being a member for the finance department for the past 15 years of my life, of course, our job as finance, as CFO, as leader of finance, is to make sure that the company will make money while fulfilling the mission, right? And so the way we look at DSTs, it's simple. Like the challenge that we have as finance is how can we keep accomplishing our mission with these new taxes? Because we operate on the edge in the margin. As I mentioned, like, it's a very small difference between having a margin that makes your platform a good one, or someone that can survive because it has a profitable margin, and the margin that makes you lose money. We saw a case recently from WeWork, from Uber, that the investors were challenging this margin, saying, okay, you cannot operate with 10%, you cannot operate with 12%, but you can operate on 15, 16. So it's a very small difference between a positive margin and a negative margin when you think platforms. And we are not passing this through price, but DST will force us to do so, right? So if you go to the next slide, I prepare some step-by-step on the decision-making since the first moment. So, but basically it happens like this. I usually get an email or a push notification, or some of our lawyers call me and say, okay, there's a DST coming, it's new, they're discussing a 16%, a 18%, or whatever it is. And this should come in 3 months or 2 months or 6 months, whatever. The first thing we do is to test elasticity on price for that market. So it's exactly this question, okay, do I have space to increase prices without losing demand? Or if I increase price, demand will go down and offer will go up. So I'm changing the equilibrium again. Usually, as I mentioned, 99% of the case, there is no space to add X% of taxes without changing prices. And then you go, what I call here Sophia's choice, but it's not that dramatic. But every finance department needs to pass through this decision. Okay, how much I will increase price in order to get a positive margin even after DST, or should I do not pass everything through price and keep my demand a little bit higher than it would be in equilibrium? It's very hard to make this decision because basically you know that if you increase pricing 16% to reflect or to react to a 60% DST, your demand could go down 25% or 35% or 40%. So here's what I call Sophia's choice. Okay, are we going for more people buying our product, buying our technology, buying our service, or are we going for less people with a positive margin? And here you have a conflict between the mission of the company and making money while you accomplish the mission, right? Because we are the finance department. So usually the finance department is the one that makes this analysis, and after some time testing elasticity, doing some testing, some specific sectors of the market, we make a recommendation to the global leaders, to the COO, to the CEO, say, okay, we need to increase price in 7%. I've never seen a recommendation, actually I've seen, but like it's rare to see a recommendation that say, okay, we will not increase prices because we have enough elasticity, we have enough margin here to survive. So usually there is a price increase. So what it's very important for the government and everyone working on this to know is that, as I mentioned before, the price increase will change the market, will change the equilibrium of the market. So immediately when you increase price, you know that less people, less agents will have access to that technology. And it's sad to see this as an economist, because economists for the past 50 years have been discussing how to eliminate transactional costs, how to eliminate externalities, how to eliminate asymmetric information in markets. And digitalization achieves all this. To become digital, it's a very intelligent, disruptive way of doing all this. And then suddenly the governments bring all the transactional costs back with a simply unilateral measure of creating a DST. So I don't need to tell you guys that all this happens internally when a DST is created, but we, the industry, we hate it because of many factors, right? And it's not that we hate it because we're gonna make less money. That's what I'm saying, guys. We will not make less or more money. It's gonna be neutral. The impact will be on price. So we hate it because it will be harder for us to accomplish our mission, not our mission to be profitable, our mission to change the world. And this is sad, okay? And then after all this happened, we got an approval from the global leaders, from the board, say, okay, you can increase prices 7% in Mexico, and then you need to implement, right? So you need to do this change in your system, you need to prepare your operations to be compliant, you need to prepare reports, you need to fulfill the returns, you need to create foreign tax ID for your foreign company, for your company abroad, and then you start to be afraid of PE and all those things. But this is implementation. Like after everything else, it's approved. It's a lot easier to do implementation, but it takes a couple months at least to make something like this work in the normal operations of a company. Okay. Next one, please. So when working with law firms and Big Four or Big Eight or whatever, but consulting firms in general, advice that I have that would make probably easier for you guys to attend your clients. You are lawyers here or work for firms. A better understanding of the product and pricing scheme. So it's important for you guys to understand what the product's about, how pricing is defined for that product. Whenever analyzing a case from Uber, it's interesting to think about this, what Uber's about. It's about people thinking if they should leave their home and give a ride or not by a price X. So this pricing scheme helps you guys understand what Uber is trying to achieve and why DST could be very impactful for that on pricing pressure. Second one is related to that, embrace the company's mission and what drives decision-making. So it's what I say, like what drives decision-making here at Gympass is to help people to find an activity that they love, to help people to be healthier. So whenever we are deciding about DST, really, we are not deciding about DST specifically. We are not deciding about these taxes or how to be compliant to these taxes. We are actually discussing, is this tax a roadblock for us to help people find an activity to love? Because this is our mission. This is what it's all about. And the other ones, in the same sense, like tax planning, it's important. I know I have been living companies have been paying me to do my job on tax planning for the past 15 years. So I know tax planning is important. I know that the perfect global structure will be the difference between a bottom line result, positive or negative. But this is not what we sell. We are not the best company in the world if we have the best global structure, if we have the best tax planning. We are the best company in the world if we are fulfilling our mission every day in everything we do. So it's all about the mission. It's all about the company's objective. Tax planning, tax structure, tax strategy comes on top as a plus. So do not imagine that in the other side, you're going to have someone as excited about the tax planning as you guys are. Usually I am, but you must remember, okay, it's not about selling the tax planning. It's about helping the company to accomplish the mission. Okay? And then I brought here, like the next slide, some examples that we passed through lately and challenges that we are passing through. So in the past 3 months, I've worked in not 3 months, like Frank's a bit older, but the past 1 year, I worked in some cases. We are implementing, we have now decided how to operate in Mexico and Chile. So we are now in process of getting a tax ID in both Mexico and Chile for our US company. So 2 countries that for a long time have been discussing these legislations, have been discussing how to do it. They have these unilateral measures and we will comply. They're not super hard to comply with, but you need to create a local tax ID for your foreign company and start to file returns every month. In the case of Chile, it can be quarterly, but at least quarterly. So you need to prepare the reports and everything to attend. But what's important, based on everything I said before, we are increasing prices in both countries. So, okay, we will be able to do, yes, we will be able to do. We are not leaving those markets. No, we are not leaving those markets. We will try to accomplish our mission in both those markets, but we are increasing prices. And when we do that, we know for sure that less people will consume Gympass. And Gympass is an amazing product that has a very beautiful mission. And it's sad for us to know that this internal decision we had of increasing prices in X% will end up meaning that less people will consume our Gympass service. But like we are attending to the Mexican, the Chilean case, both created price increases. The French case, it's an interesting one because for months we were analyzing what it would mean a French DST for our business. We are not that big in French, and we have strong competitors there, so it's a very competitive market. And in case of a DST that would trigger a price increase higher than 10%, it would mean that probably we would leave our operations in France. So we had all these discussions regarding, okay, if this comes up, we're gonna have to leave France. It's impossible for us to pass this price increase and keep acceptable market size in order to be in France. So it would not justify the fixed cost we would have there. And then suddenly with all this discussion, pressure from US, the threshold came up, and the threshold was high enough to do not get to Gympass. So it was an interesting case that we invested some time and some money to understand it better, and then the threshold came, and it would not get Gympass given our size there. So besides being unilateral, all this movement that those countries are doing, it's very hard for small or medium-sized companies to keep update on everything that is being discussed, everything that is happening behind the scenes. It's not all companies that will be able to pay for a consulting firm that will be present in the Congress or whoever it's discussing these legislations and keeping us informed real time about everything that is being discussed. So there are costs involved in the process of creating a digital service taxes for the companies that should be considered as well. If tomorrow there is a discussion in a new country where we have business, and it's a discussion like Brazil. Brazil is a great example. All the companies now that I work with are discussing, okay, should or should we not have some kind of policy consulting firm helping us in the Congress so we can have this real-time information about the discussions and we can actually influence decision-making. But it's a huge investment to do that, right? So does it make sense or does it not make sense to make this investment? And it's hard to discuss this as a company. And this was very clear in the French case.
I think do you have anything to add to the French case?
No, I think Pedro's feeling is the same feeling we have with other clients in all the topics discussed, like whether or not is worth it for the business, whether or not there's like an internal burden and formal obligation, as Pedro was mentioning. Yeah, nothing to add over there.
Can you share with us the Mexican case then, that I see that you have one?
The Mexican case, it's interesting because so the Mexican case, like Mexican and US nowadays, they are
you can be honest, Pedro. I know there's a big audience here, but you can be honest.
No, of course. Mexican case, it's interesting because US and Mexico are not in the best diplomatic moment ever, right? With the wall and everything that was being discussed in the past years. So we knew that Mexico would be would not be willing to be softer or soft regarding US multinational companies. We knew that they would come with some kind of legislation, and we knew this since ever. And again, it was the same thing. Like, I think the discussions in Mexico were very centralized around Netflix, Uber, I think Amazon was being part of the discussion as well. But everything that was coming as updates of the legislation and new announcements, and even now that they create the system for you to pay taxes, the system does not work for Gympass, because the system that they create for you to inform the payments you are making to your supply, that in Gympass case is fitness facilities like gyms, the system only works for individuals. So the system was 100% created to attend Uber, because the system works perfectly for Uber drivers. And I cannot use the system myself because it does not work for companies. Yeah, so I cannot inform that I'm making a payment to a gym because it only works if you inform an individual tax ID. So it's a case that shows that the government think, okay, we are creating, and before the name DST, I don't know if you guys remember, but we used to call this Netflix tax. So the guys think, okay, I'm going to create a tax to get Netflix. And of course, we're going to get Uber as well. Yes, Uber. We hate those guys, right? They do this all. They take the jobs out of tax drivers, whatever. So let's get Uber and Netflix. And they forget that there's a lot of other companies, not even technology companies, a lot of other companies, even from other sectors, that will be impacted because they all have digital services. They all have digital activities. And these other companies from all these different sectors, like in our case, the gyms, I don't know if the drivers from Uber pay or not pay taxes. Like, it's another discussion. But the gyms that I have in my platform, they pay VAT. Every time they get a user of Gym Pass there, they pay VAT. And they forget that when they create a digital service tax of a US platform operating in Mexico, they will not get only Uber. They will get Gym Pass as well. And in Gym Pass case, if they tax my gross value of the transaction, it is a double taxation, because in my case, I'm 100% sure that the gyms are paying VAT. So Mexico is a very emblematic case that when the system was created and became available to the taxpayers, and clearly it was not working for payouts made to companies, became clear, guys, not only you haven't thought about other companies when you did that, as the system is not even ready for other companies. This is how bad the DST discussion was. You guys simply want to tax Uber and Netflix, and you create a tax over Gym Pass that it's double taxing fitness activities from your population. That, by the way, would make your population healthier, would reduce health costs, would reduce health insurance costs, and all this. This is how bad this DST was. This is how superficial was the assessment on impacts on the economy. And more than that, it was so focused on Uber, it was so focused on Netflix, it was so focused on these specific big companies, that if you have a business model that it's slightly different in the way you do pricing, the way you do subscriptions, Luciana can keep me honest here. It took us 3 or 4 weeks to understand ourselves on trying to explain the different business model that Gympass had, because the legislation simply does not work for my case, because it's a different business model. You cannot do analogies because it's a new legislation. You don't have jurisprudence to analyze because it's a new case. So like you get lost, okay, how I'm gonna place myself here in a legislation that it's clearly not made for me, in a system that clearly does not work for me, and in a pricing scheme that clearly nobody gets, right? So Mexico was very interesting. We made a decision, again, with a very high level of uncertainty, but we made a decision that makes more sense for us, that is to pay VAT over my margin, over my net revenue that we call, and not over the gross value of the transaction, exactly to avoid this double taxation between what the gym gets and what Gympass gets. So we are paying over our margin, we are not paying over the whole value of the transaction. But there's a very high level of uncertainty on making those decisions.
And I think it will certainly benefit you to have an open discussion with the Mexican tax authorities, right, Pedro? I don't know, Diana, if you can comment if that is a possibility or not, but I think this is something that we see more and more happening in lots of countries. So taxpayer and opening their hearts to the local tax authorities. So what is the view from a Mexican perspective?
Yes, thank you, Luciana. Thank you, Pedro, for your comments, sincere comments. I really understand your concerns, and I share them definitely. Yes, I think it is a possibility to approach the Mexican tax authorities. They are having a kind of negative attitude right now towards digital platforms, but we can find a way to try to explain them the business model of Gympass. Definitely every I think this is happening a lot to clients. The Mexican Tax Authority, as Pedro mentioned, did not have all the business models that were going to be affected by these new provisions. And I definitely think that they should have thought of that. They had a pilot program with Uber, and of course that guided all of the discussions towards that business model. But even not every sharing economy platform has the same business model as Uber. So I totally understand. I think that we can find a way to try to explain the differences of the business model, the uniqueness of this business model, and try to find a middle path for comfortable with complying, because even the implementation of the new regime has been complex. There are no simplified procedures as opposed to the Chilean case, and I think that should change, and we should raise our voices for the Mexican tax authorities to know that this is it's not that simple to just have legislations and not help foreign residents to comply.
Thank you, Diana. Pedro, but I think you had a good experience with Chile, no? At least.
No, Chile, that's what I say, like Chile was very simple, very straightforward. So they understood that the main, so guys, whenever DST is created, what is our main objective? To do not pay DST over the gross value of the transaction, okay? What I mean with gross value of the transaction, if you think Uber, to make it easy for everyone, Uber should not have to pay DST over the total value of the ride, of the trip, if you call trip like the ride, but only over the Uber revenue of it. In the case of Gympass, we should not have to pay DST over the subscription we Gympass charge, but the subscription minus what we pay to the gyms. Why that? Because the gyms are already paying VAT, right? So this cost is already included in the price of our service. When we do a subscription of 100, and then people go to the gyms, and then we send 80 to the gyms, our revenue, our transactional base is the 20, it's not the 100. Because the 80 is already been taxed there in the gym. So the main goal whenever DST comes is to make sure that we will use as base only our net revenue, not the gross value of the transaction. And Chile legislation is super clear on that. Chile legislation does not open space for discussions. It's clear, okay, you're gonna pay VAT, you're gonna pay the DST that they created over the net revenue. And when this happens, you don't need to invest a lot of time and a lot of discussions in order to make sure that it's the net. So Chile was great thinking from this angle. It's easy to do, like we created tax ID in 5 minutes ourselves. We just went to the web page and the tax ID was issued like in 15 minutes. Mexico, it looks like it's gonna take 6 or 7 weeks for us to get a tax ID. So like this is the tier, so Chile was good on that. It does not change the fact that our product, it's more expensive now in Chile. Because even it was over net, even if it was easy to get a tax ID, we didn't have space in our margin to have a 4 or 5% extra taxation. So anyway, we had to adjust prices. So Chile is a good example on how to do. It worked well. If you can do quarterly, it's good. So you don't need to do the returns every month as well. That it creates more complexity. So you can do quarterly, it's also good. But anyway, it impacted the price of my product. So great in one sense, but it's still not ideal for us.
So I know we have exceeded today, but I just want to hear your final words about what do you expect that will happen in Brazil.
Yeah, and let me just make an interruption here. Pedro, since you like to bet, what's here?
What is your bet? Mexico, Chile.
Sorry?
What is your bet if Brazil will be more like Mexico or Chile?
So my bet, and I'm an optimist guy, is that the Brazil DST will not go through. My bet is that we're gonna have this new VAT kind of system without PIS and COFINS and a unique taxes, but not the CG over digital service tax. But I could be seeing the glass half full. Let's see.
Okay, thanks everyone. It's been a great discussion. I really appreciate everyone staying. I see we still have loads of participants, and the session was supposed to have ended 20 minutes ago. So thank you very much to all our speakers, but my special thanks to the audience for bearing with us for all the time and for keeping, I hope we've kept you interested. If you have any questions, please feel free to email us, and we'll organize separate conversations with you or reply any questions by email. You will receive a copy of this recording after the conference is over, and as I said in the beginning of the conference, you also receive the link for download of a book. Thanks very much. Have a great day and enjoy our other sessions of this conference.
Thank you. Have a good day.
Thank you.
Bye.
Thank you all. Bye-bye.
Bye.
Bye.